In this lesson, we're diving into Section 18, Brokers and Agents, a critical part of the residential purchase agreement that explains how broker compensation works and defines the scope of duties for real estate agents. In this section, we'll break down 1. Who is responsible for paying the broker? 2. Which agreements determine commission amounts? 3. Why the buyer's broker is recognized as a third-party beneficiary. 4. Key limitations of an agent's role. 5. What agents cannot guarantee about the property or transaction. 6. Why clients should seek legal, tax, and professional advice when needed. By the end of this video, you'll understand exactly how Section 18 protects both the brokerage and the clients, and how to explain these responsibilities clearly in your transactions. Let's get started with Section 18, Brokers and Agents. Section 18A, 1. Broker compensation. 1. Who pays the broker? Seller, buyer, or both, as specified in a separate written agreement with the broker, e.g., listing agreement, buyer representation agreement, or compensation instruction. 2. How much is paid? The amount or percentage is not in the RPA. It's in that separate agreement. If it's a percentage, it's based on the final purchase price. 3. Important warning to the buyer. Buyer is advised that their broker should not receive compensation from any other source that would put the broker over the amount stated in the buyer representation agreement, unless that agreement allows it. Basically, if you've promised the buyer a certain fee structure, you don't secretly collect more somewhere else. 4. When is compensation actually paid? Typically at close of escrow, or if escrow doesn't close, then whatever the listing or buyer-broker agreement says controls, for example, a fee due if seller cancels in bad faith. Key teaching points to remember. The RPA does not create the commission amount. It simply recognizes that commission is handled by separate broker agreements. Agents should always have a signed listing agreement or buyer-broker agreement that matches how compensation will be paid. Section 18A2. Third-party beneficiary. Buyer's broker. What this means. 1. Seller acknowledges that the buyer's broker is a third-party beneficiary of this agreement for the compensation term. 2. That means buyer's broker may have the right to enforce payment directly against seller if seller agreed in writing to pay a certain amount and then refuses. If the seller has agreed that part of the commission will go to the buyer's broker, that broker isn't just hoping to get paid, they're written in as a third-party beneficiary and can pursue the seller if that agreed amount isn't paid. Section 18B. Scope of duty, limitations on what agents do. This is the what your agent is not responsible for paragraph. Buyer and seller both acknowledge and agree that the agent's role is limited. Price decisions, I. 1. The agent does not decide what price the buyer should pay or what price the seller should accept. 2. Agents can advise, but the final decision is client's choice. Condition of the property, 2. 1. Agent does not guarantee the condition of the property. 2. That's why we have inspections and contingency periods. 3. Work done by others, 3. 1. Agent does not guarantee the quality or completeness of inspections, services, products, or repairs done by seller or third-party vendors. 2. Example, if a roofer misses a leak, that's not automatically the agent's liability. 4. No duty to inspect common areas or off-site areas, 4, and fee. 1. Agent is not obligated to inspect common areas, condo stairways, HOA grounds, etc. Areas off the property, nearby lots, streets, neighborhood conditions, too. Unless something is visually observable from a reasonably accessible area or is known to the agent, they aren't responsible for discovering it. 5. Public records and permits, 6. 1. Agent is not responsible for searching public records or verifying permits. 2. That's a job for title, city/county departments, or other professionals. 6. Boundary lines or other title matters, 7. 1. Agent does not identify property boundaries or easements. 2. For that, you need a surveyor, title company, or real estate attorney. 7. Square footage and marketing info, 8. 1. Agent does not verify square footage or other details in NMLS, flyers, advertisements, websites, etc. 2. Buyers must verify size, lot, and improvements if important to them. 8. Fair market value. 9. 1. Agent is not responsible for determining the fair market value of the property or personal property. 2. They can provide comparables and recommendations, but value is ultimately the market's decision. 9. Legal or tax advice. X. 1. Agent does not provide legal or tax advice. 2. Clients should consult attorneys, CPAs, or other licensed professionals. 10. Other professional advice. 11. 1. Agent doesn't give advice beyond the knowledge and experience reasonably required to perform real estate licensed activity. 2. In other words, if it's outside normal real estate practice, structural engineering, environmental hazards, complex tax planning, the client must hire the right expert. 11. Strong recommendation to seek professionals. 1. The paragraph finishes by urging buyer and seller to seek legal, tax, insurance, title, and other professional advice whenever they have questions. Section 18 reminds everyone that the RPA is between buyer and seller and that brokers are paid under separate agreements. It clearly limits what agents are responsible for and pushes clients to use the right professionals for inspections, legal questions, tax planning, title issues, and more. As agents, our job is to disclose, advise within our expertise, and refer out when something is beyond a typical real estate license.